So I've been studying hearsay. I've done about 500 questions. I've met with my professor after every single class, and except for 3 times I didn't meet with my professor after every single class, and I made up for 2 times for each of the times I didn't meet up with my professor. I've done about 500 questions, 150 of which of those I've done 2 times because they were rather complex questions. I just wanted to get them precisely correct, because sometimes you have multiple layers of hearsay and you need to make sure that you're sticking within the layers, which I think are sometimes the most funnest and most complex. But I'm just going to do this because I've been studying from my videos as I'm continuing to study. So I'm going to talk about hearsay right now, not in regards to non-assertive conduct, starting off with non-assertive conduct. Non-assertive conduct without an intent to convey information is non-assertive conduct, and therefore not included under the hearsay rule. So it's not hearsay if it's non-assertive conduct. However, what about when we're talking about the Wright v. Tatum rule, when a writing implies something? So here's the Texas rule for hearsay. Proof of a particular fact for which it is itself not a matter at issue, but which is relevant only as implying a statement or opinion of a third person on the matter of the issue, is inadmissible in all cases where such opinion or statement, not oath, would be itself inadmissible. The federal rules say that implied assertion is not hearsay because there's no danger of insincerity, and it's only hearsay when it is explicit assertions, intentional assertions. Texas Rule 801 decides matter asserted, any matter explicitly asserted, and any matter implied to the statement. The probative value of the statement flows from the declarant's belief as to the matter. Let me repeat that. Texas Rule 801 defines matter asserted as any matter explicitly asserted, and any matter implied by a statement. If the probative value of the statement as offered flows from the declarant's belief as to the matter. Excuse me. Texas treats the letters from the Wright v. Tatum case as hearsay. The federal rules treat the letters not as hearsay because we are worried about the insincerity of explicit assertions are hearsay. Because the letters are both implied and express, we can't explain. So, in regards to implied, the relevant on probative matter is the implied matter of competency in regards to the Wright v. Tatum case. Express, they want to do business with him, and insincerity is the implied policy. So in the Wright v. Tatum case, you had letters coming to a guy for business. They're used to show that he had a capacity to do business, but those weren't expressly said in the letter. Those were the implied assertions from saying they want to do business with him, that they believe that he is competent for business. And thus in Texas is hearsay, but not under the federal rules. Matter asserted. 3 steps. Is there a statement? Was there a matter asserted? And what am I offering the statement to prove? If I'm offering to prove the truth of the matter asserted, then it's hearsay. Matter asserted, what I'm trying to prove, cannot overlap. They have to be separate. When a statement is not hearsay, it's for impeachment. Verbal acts, parts of speech, when the words are spoken have independent legal significance, solicitation, such as solicitation, they're not hearsay. Effect on listener or reader does not have to be limited to the reader, to the immediate listener, I mean. And then 4, verbal objects being offered to prove the identification, such as logo trademarks of companies. 5, circumstantial evidence of state of mind, and 6, circumstantial evidence of memory of relief. There's multiple problems here. Examples, hypotheticals, hearsay rule under 801. Getting close to the hearsay exceptions. Yes, we're here. Alrighty. 4 main groups of exceptions. 801D1, prior statements by a witness. 3 exclusions. Offering for its truth, a jury can consider it for its truth, not admissible for non-truth as impeachment, but for substantive evidence. All right, here are the 3 of 801D1, statements by witness. Prior and consistent statements, prior identification. 2, 801D2, makes up admissions of doctrines as mission of party opponent. And then we have 803, hearsay exceptions, availability of declarant immaterial. 804B, hearsay exceptions declaring unavailable, and 807 residual exception catch-all.